Well, affirmative action is on trial. Today, a critical decision by the Supreme Court may decide who gets into college. At issue is Michigan's Prop 2, a law banning any consideration of race in public college admissions. But can a law meant to cut down on discrimination be discriminatory? Here to weigh in, Fox News senior judicial analyst, Judge Andrew Napolitano.
It's hard to follow, Brian.
No. So I'm not.
Oh, boy.
So
all right, so
this is an interesting case.
Yes, and it's a long saga in the state of Michigan involving its terrific public university, the University of Michigan,
yes,
owned by the state. So a couple of years ago, the University of Michigan was openly using race as a basis for admitting students. Its argument was a diverse class,
sure,
a racially diverse class helps everybody. The people who got in there because we gave them a little bit of a boost because of their race, and other people because they're exposed to different types of people. Supreme Court basically said, you can do that, you can use race, it can't be the deciding factor, it can't be the principal factor, but it can be a factor. Public in Michigan didn't like it, and the public at a referendum, a November election, voted to amend the Michigan Constitution to prohibit all aspects of Michigan government, from police to school boards to the University of Michigan, from using race for any reason.
Right.
And that is now been challenged before the Supreme Court. Two lower federal courts said, you can't do that. You can't have such an absolute ban in your Constitution.
It's universal, too universal, right? They were saying.
Well, here's the issue. One argument is the whole reason we have the 14th Amendment, one of the three post-Civil War amendments, is to prohibit the states from using race. We all know the horrible history of states using race to treat people differently in America. So can the state of Michigan say, you cannot take race into account under any circumstances? You, the government, have to be colorblind. Two lower federal courts said no. This will be argued before the Supreme Court this week.
Right, and argued by Mark Rosenbaum. He's a chief counsel for the ACLU, who basically wants Michigan to be able to set its own admission policy aside from the state. But how can they do that if it's a state-run university?
Well, they can't. They can't. But the University of Michigan, which, again, I can't underscore enough the high level of education there, nevertheless, has to follow state law, like everybody in Michigan has to follow state law, especially if you are owned by the state and the state says you can't use race. The confusing thing is the Supreme Court has failed to give very crystal clear rules to states as to when they can use race and when they can't. And that's why this keeps coming back.
Okay.
This is another opportunity for the Supreme Court to say, here's the law. When Justice O'Connor wrote an opinion about race and Michigan, she said, the University of Michigan can use race, but only for the next 25 years. When the Supreme Court gives ambiguous rulings like that, it creates confusion.
Sure.
Hopefully this is the opportunity for them to say, once and for all, you can use race, you may use race, you can never use race.
Sure. Maybe an opportunity to define that clearly,
yes,
as you just said, Judge. Thank you so much.
Pleasure.